The fluorescent lights in the courthouse hallway hummed at a frequency I had trained myself to ignore. I had spent enough time in public buildings to know that certain sounds, certain particular silences, either unmade you or they didn't. I straightened the lanyard on my badge out of habit, even though I wasn't wearing one, pressed my folder against my side, and walked through the double doors into courtroom 4B of the Fulton County Superior Court in Atlanta. She was already seated. Third row, left side, wearing a charcoal blazer with a cream blouse. My biological mother. I recognized her the way you recognize a landscape from an old photograph. The proportions were right, but nothing felt the way you expected it to feel. She was 61 now. She did not look at me. She was watching the plaintiff's table with the focused, acquisitive attention I remembered from childhood, the way she looked at things she had decided she was owed. I had not spoken to her in 19 years. I had not been afraid of her in 17. Those are two different milestones, and they matter in different ways. Let me explain how we arrived in the same room. I was 9 years old when my parents left me at the Atlanta Greyhound Terminal on a gray Wednesday in November. My father said he needed to check the departure board. My mother gave me a bag of crackers, pointed to a row of blue plastic chairs near the west wall, and told me to sit there and not move. She said they would be back in 10 minutes. She said this with the same flat assurance she used when she told me to make my bed or finish my vegetables. Not unkind, not warm, simply factual. I sat down. I ate the crackers in approximately 8 minutes, because I was anxious, and I did not know yet that I was anxious. I watched the entrance doors for the next 4 hours. A depot employee named Beverly finally noticed me. She had a thermos clipped to her bag and a name tag with a small American flag sticker on it. She asked me where my people were. I told her they were checking the board. She looked at the board, which was 40 feet away and visible from where we were both standing, and then she looked back at me. She nodded the way adults nod when they are trying to keep their faces from showing you the thing their face is already showing you. She said she was going to make a call and offered me a bottle of water. Police came. Then a caseworker. Then more waiting in a room with plastic chairs and a television bolted too high on the wall. I kept constructing explanations. I was 9. It was the only architecture available to me. What I didn't learn until I was 27, standing in a records office in Fulton County with a legal pad and a very specific reason for being there. They described me as emotionally volatile. They said I had a history of running away. I had never run away from anything. I was in 4th grade. The most defiant thing I had ever done was hide a library book under my mattress because I wasn't finished with it. They had, I would further learn, taken out an insurance policy on me 20 months before that Wednesday. It paid a lump sum upon a qualifying disappearance exceeding 18 months. They collected $80,000 when I was 11. I didn't know that part yet. I'm getting ahead of myself. His name was Gerald Okafar. He was 56 years old, a recently retired hospital administrator with a precise, unhurried manner and the habit of carrying things in his jacket pockets that seemed impractical. He came to the family services waiting area on a Tuesday because he had agreed to mentor a teenager in the transitional housing unit down the hall and arrived to find the meeting had been rescheduled. He was about to leave. Instead, he sat down in the chair next to mine and asked if I knew how to play dominoes. I told him I didn't. He said that was easily fixed and produced a small travel set from his left pocket. He was patient without performing patience. He explained the rules twice without any indication that he found my forgetting inconvenient. When the caseworker came to move me to a temporary placement, he stood and shook my hand with full seriousness and told me I had a good eye for patterns. I assumed I would never see him again. He returned 6 days later with a library card he had requested on my behalf, and a paperback novel about a girl who uncovers the truth about her grandmother's past. He had gone through official channels, filled out the correct forms, introduced himself to my caseworker with documentation. He visited every week for 11 months. Through 3 placements. Through a stretch of several weeks when I stopped talking much at all because I had run out of language for what I was carrying and didn't know how to explain that. He never pushed. He brought the dominoes. Once he brought a small cellophane bag of sour cherry candies that I hadn't tasted since a birthday party in first grade, which I hadn't told him about. I don't know how he knew. When I was 10, he asked, formally, if I would be open to him applying as a foster parent. He said he wanted me to know I had a real choice. He said trust had to be built and he hadn't finished building it yet, if I was honest, and he knew it. I said yes before he finished the sentence. I moved into his house on a Saturday in March. A brick 2-story in Decatur, spare and organized, with plants on every windowsill and medical textbooks stacked on the kitchen counter next to cookbooks. It smelled like coffee and dish soap and something green. He showed me my room. There was a yellow quilt and a lamp with a white shade on, which someone, Gerald, had drawn small constellations in permanent marker. He said I could change anything I wanted. He meant it. I kept the quilt. I kept the lamp. I have them both. What Gerald never mentioned in all the years we shared that house and all the years after was that he had money. Not a comfortable salary, not careful savings. Actual, substantial generational money that had come from his father and been multiplied by Gerald's particular combination of institutional knowledge and extreme disinterest in spending it. He drove a 10-year-old Civic. He bought reduced for quick sale produce. He repaired things himself. I knew he wasn't struggling, but I understood him as a careful man. He never corrected that understanding. He said once, when I asked why he didn't update the kitchen, that the kitchen worked. That was the full extent of his commentary on the subject. He paid for my undergraduate degree without describing it as exceptional. He paid for my master's in healthcare compliance without describing it as anything at all. When I finished my licensure exams and went to work as a compliance officer for a regional hospital network, he took me to dinner and ordered good wine and told me he was proud of me. Just that. I had to look at the window for a moment. He pretended not to notice. He was good at that. I was 33 when Gerald called to say he wanted to talk in person. He was 77. He had been slowing down in small, dignified ways for 2 years, and I had been watching it and not watching it simultaneously. We sat at his kitchen table the way we had sat at it hundreds of times. He told me about the money the way he told me everything. Matter of fact, no performance, information being transferred because the time had come for it. He had updated his will. He wanted me to hear the specifics from him, not from an executor after the fact. The estate was valued at $4.2 million. I sat still for a long moment. I said his name. He said he knew. I said it was everything he'd built. He said he knew what it was, and he knew who should have it. There was nothing to argue with in that sentence. Gerald had never said anything he didn't mean. He died the following spring, a quiet Tuesday morning at home. I took 3 weeks off work. I packed his house slowly, and with care. I kept the domino set. I kept the mug he used every morning, which had a small chip on the handle that he had never bothered to replace because it still worked. I donated his clothes. I cried more than I expected and also exactly as much as I needed to, which turned out to be the same thing. 8 weeks after the estate was filed, I received a certified letter from an attorney representing my biological parents. They were suing for the full estate. The legal theory, such as it was, argued that as my biological next of kin they held a prior claim to any inheritance I received, and that Gerald's estate should transfer to them as my family of record. They made this argument despite the fact that a family court had terminated their parental rights when I was 11. They made it despite the fact that Gerald had legally adopted me when I was 13. The return address was an apartment in Marietta, Georgia. 22 minutes from where they had left me at that terminal. I read the letter twice. I set it down. I was not trembling. I was not overwhelmed. I was thinking with the particular focused clarity that Gerald had helped me build over 24 years. I called my colleague Delia, who runs the estate and litigation practice at the firm where I consult. She came over that evening, read the filing, and looked at me over the rim of her glasses. She said they had no standing. I said I was aware. She said whoever drafted this either didn't understand basic estate law or assumed I didn't. I told her that assuming I didn't understand things was something of a family tradition. She said she would represent me. I said I wanted to handle the courtroom myself. She was quiet for a moment. Then she said fine, but she would be at my table during every preparation session, and I was not doing this alone. I agreed. I filed the response. We counterclaimed for legal fees and frivolous litigation. And then I did one additional thing because I had spent 6 years in healthcare compliance and I knew precisely how to follow a paper trail. I hired an investigator. She returned her findings in 9 days. The missing child report with its fabricated behavioral history. The insurance policy, executed 20 months before the terminal. The payout, $80,000 claimed when I was 11 under a prolonged disappearance clause. Both signatures. The notary. Insurance fraud, first filed in 1996 and never investigated because nobody had connected the policy to a deliberate act. Because my parents had been careful. Because I had been a child with no knowledge of what had actually happened. I forwarded everything to the Fulton County District Attorney's Office. Then I went back to work. The hearing was assigned to Judge Carol Ashburn, who had the manner of someone who has encountered every variation of human reasoning under pressure and has retained, despite this, a genuine interest in how people talk themselves into things. She looked at the plaintiff's filing. She looked at our response. She asked their attorney to walk her through the basis for standing. What followed was 14 minutes of the most uncomfortable legal improvisation I had witnessed in a courtroom. When he finished, she turned to me. I stood. I had prepared for 10 days. I spoke for 8 minutes. I laid out the adoption record, the termination decree, the statutory framework that left their claim not merely weak but structurally non-existent. I was calm. Gerald had taught me over decades of kitchen table conversation that precision was its own form of respect, that saying exactly what you meant saved everyone, including yourself, a great deal of unnecessary suffering. The judge ruled from the bench. The case was dismissed. Full legal fees were awarded. She used the phrase without legal merit and then used it again in a different construction, which was not standard practice, which meant she wanted it in the record twice. As my mother stood to leave, she looked at me directly for the first time since I had walked through those doors. I don't know what she was looking for. Some signal that she had still reached me, even losing. I looked back at her. I gave her nothing. Not because I was still wounded. I had done that work, years of it in a therapist's office on Tuesday evenings. But because there was nothing left of me that belonged to her. She had made a decision about that the afternoon she handed me a bag of crackers and pointed to a row of blue chairs. 3 weeks later, the DA's office filed charges. Insurance fraud, filing a false report, fraudulent misrepresentation. Dalia texted me one line. It's moving. I sat at my desk for a minute. Then I finished the report I was writing. In the fall of that year, I established the Gerald Okafor Fund, which provides healthcare advocacy and legal support to children in foster placement navigating institutional systems alone. I funded it with a portion of the estate. I still take cases myself when I can. I sit across the table from children who have learned to make themselves small and quiet, and I say, which is what I mean, and nothing more. The domino set sits on my desk. Gerald always left it mid-game. A problem to return to, he said, when you had enough patience to see it clearly. I have thought about patience a great deal over the years, what it costs, what it returns, the difference between waiting and enduring. Gerald spent 11 months visiting a silent child in other people's houses before he asked for anything. My parents made their decision before I finished a bag of crackers. Those two facts are the entire shape of my life. Have you ever found yourself holding space for someone who had already decided to leave, still defending them, still waiting at a door they locked on their way out? I'd like to know how long it took you to stop. And what you did with the room once you finally let yourself use it.